The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Please be seated. All right, we're prepared to begin with our first case, Brady versus City of Myrtle Beach. So when you're ready, we'd be glad to hear from you.
May it please the court. Thank you for allowing me to present arguments this morning on behalf of my clients, JB&HM Enterprises, Inc., Danny Group, LLC, Blazian Promotions and Company, LLC, and Hector Melendez. This case is based on our belief that the City of Myrtle Beach invidiously discriminated against minority bar owners in the City of Myrtle Beach. They abused their police power to harass them, basically make their businesses impossible to function, all for the purpose of ridding an area in the City of Myrtle Beach known as the Super Block. It's almost a pentagram-shaped series of strip malls that all circle a central parking area. My clients all ran nightclubs, minority nightclubs, in which the clients...
You've thrown up an awful lot of claims, haven't you?
I don't think so, Your Honor. In terms of, what do you mean by claims?
I was wondering if there was any part of the Constitution that you neglected. Would you call it a Hail Mary complaint?
No, Your Honor. I thought it was very pointed and specific, and there's actually a case that I've cited out of Kentucky, Covington, where exactly what we complained of, the district court allowed that to move forward, saying that they did state a claim for a 1985 conspiracy. We think it's one of two things.
So if you throw enough against the wall, you hope something will stick?
Well, Your Honor, I think we threw a lot against the wall in this case. You know, we have the city manager, the mayor, the police chief, all of them saying there's no question they were owned by minorities, and they all said these were minority nightclubs. They were black clubs.
Can I just clarify because there are a lot of claims, what particular claims we're talking about? Because I thought the one claim you didn't bring was an equal protection claim. That seemed to be pretty clear. So you're not arguing equal protection right now, are you?
No, we're arguing just a violation of they took away their rights to operate their business based on the fact that we believe there's evidence that they were minority clubs. They wanted to rid the Superblock of the minority clubs, as they stated in their emails.
You did make a motion at the end of the defendant's case to amend the pleading, so are you not arguing that you made that motion before the court?
Yes, ma'am.
So you did request the district court to add the equal protection claim to the complaint?
Yes, and that goes back to the original, the first DV. He said, I don't think you brought a Monell claim, and I thought we had made it.
Can you point to any place in the record at the end of the plaintiff's case that you did make that request to the court? Because it looks like you just asked to add a party, but you never actually made the motion to add the equal protection claim at the end of your case.
I know there are two separate, we made a Rule 15 motion at the first DV, at the conclusion of my case. And then at the end of, when he changed the arguments as to why we should not be able to move forward, that's when I said, I thought all we've argued is equal protection in the entire case. So I wanted the evidence to conform with what had been presented. I mean, the claims that went to the jury to conform with what was presented at trial.
Are you claiming that you are able to amend under 15B1 or 2?
The distinction, Your Honor, I don't have the order, the motion, I mean, the rule in front of me.
So the one, I believe, is about, you have to, a party has to make an objection, and then you can, that something that you presented in the evidence is not in the pleadings, and then you can make a motion to amend.
Correct.
And I believe the second is,
To conform with the evidence presented at trial, or?
it's by express or implied consent, and I don't think you have that here.
No, I would agree Mr. Battle objected to that, but I disagreed with the judge that the pleadings did not contain those particular claims, and that was the secondary, I guess, argument that we just presented this to the.
District judges can reject motions to amend on grounds of futility, can they not?
Yes, Your Honor, but I don't think that's the situation here, because I think we showed, I mean, the judge even admitted that we demonstrated there was disparate treatment between my clients and the other owners in Myrtle Beach.
So, as a general matter, we have a beach town here, and like many beach towns, there's a cultural clash. There's a sort of strip along the beach towns. I've been to a great many of them, where people during the season and on Friday and Saturday nights, they wish to let go, and I understand that. But then there's often in these beach cultures another group of people who want their community advertised as a family-friendly place and want their children to grow up with the idea that engaging in the kind of conduct that took place in the Strip was not a teenage option. And my question is, given this cultural clash that exists in so many beach communities, why should the federal courts be the ones to sort it all out?
Well, I think in this situation, we made the claim that they improperly targeted my clients and targeted these bars. And of course, their statement, their argument is what you're saying. But when you look at their justification for what they did with the nuisance ordinance, it is at best pretextual, if not fraudulent.
Well, how can you say that they improperly targeted your clients? They brought in Mr. Coughlin, and he gave expert testimony, and he compared what they were doing doing in this community. He brought a national perspective to it and said this is well within the bounds of reason. And when I reviewed the record, I didn't hear that Mr. Coughlin's testimony was contradicted.
Your Honor,
He's saying that they acted reasonably, and that's the kind of thing that you would expect the locality to bring forward, and I didn't see any refutation of that.
Well, Your Honor, everything that he said in his testimony was refuted. He said they're trying to protect the patrons of Myrtle Beach. That is absolutely not true. The sundown meeting with Henry Brewington, when the city attorney and the police chief brought a black man and a mixed race couple and said, yeah, you're getting out of my town. No violence had occurred at that point. None. Then you look at the emails. We've decided, where David, the DRC said, you see, I'm getting rid of the bars. There's only one shooting that's occurred at that point, and it happened despite their testimony that's just absolutely false. It happened outside of the Brewington's club. It was their patron that left the club, gets shot on the street, and they shut down the club.
Well, the difficulty here was, and the record shows, that the behavior that was concerning to the municipality was spreading into the parking lots and into the streets. It wasn't just what was in the club, it was the area surrounding the club.
I understand that, Your Honor, but it's not spreading from the club. That is the Myrtle Beach, City of Myrtle Beach's property. If the property owner is responsible for crime on their property, the city has a very large problem. Because the only thing they would do is park their cruisers in the parking lot to make sure patrons didn't go to the bars.
Now, which constitutional provision are you claiming was violated?
It's that they're taking their business. They are intentionally interfering with their business to shut them down so they can acquire the property. That was,
What is taking? There's no eminent domain action here?
right. If they wanted the properties, that's what they should have done.
You're saying that there's a taking?
Yes, Your Honor.
So every police enforcement action is going to be a taking?
This is not a police enforcement action. We didn't sue the police. This is the individuals that ran the city.
No, but what you're saying is that when police come in, you can raise a targeting claim and that you can proceed under the takings clause?
No,
That's a pretty broad theory, isn't it?
Your Honor, the targeting is clear because we've demonstrated the evidence that they didn't do this to the white boys. We have testimony from Jenny Brewington. We have the CAD reports that show. I mean, you have to understand, the city paid one of their own a $5 million profit for the worst hotels in the city of Myrtle Beach that are less than a quarter of a mile from the superblock. And they said in their public statement that we have to buy these properties because they're so bad.
Okay, let's say, I hear your argument, but the question still remains, why is this not a local matter? One of the things that we ask is whether the due process has been provided under the due process clause, and that's the job of the federal courts to make sure that procedural fairness is observed. Now, you had an opportunity, there was an investigation by the municipality to begin with. If you didn't agree with the denial of the license, there was the right to appeal to the city council. You could have been counseled there. You had a lawyer to make the case. And if the city council decided to approve the administrative meeting, you had a right then to go to court and contest it further. And so the question I have is, you're making arguments about the degree of nuisance that this was, and whether there were this many shootings or that many shootings. And I wonder why that argument isn't more appropriately made first of all, before the city administration, second of all, before the city government, third of all, before the state court system. You could have explored all of that and probably did. But why should the federal courts get into it when the community that is affected by these things and the people that are closest to these things are in the city of Myrtle Beach?
Well, Your Honor, we were giving an opportunity in our trial to let the citizens speak as to whether or not this is something that they approved. And I can tell you, after the DV motion, they came to my clients and said, I'm sorry, we were going to give you everything you asked for.
Was your process curtailed in the state?
Yes, Your Honor. My clients are not wealthy people. They had spent $300,000 for the upfit of these bars, and they were not allowed to operate through the harassment of the police department and the city at the direction of the city manager. I mean, we have city employees. My clients testified to continual regulatory harassment. Rebuild the bar, it's a half-inch off. And then they called them a stupid Mexican. And then the city, and back to your point as to whether or not the culture clash is what we're saying is racist. John Peterson said on the stand, number one, if a guy comes in your club and pulls out a gun and wants to shoot somebody, there's nothing a business owner can do to stop that. Yet that's exactly what they did to my clients. They used that incident of somebody else coming into the club to do violence that he admitted on the stand they could not prevent, and said that's why their license should be taken away.
And what was the evidence that Peterson coordinated with law enforcement or told law enforcement he wanted the city to take these properties?
The
I didn't-
emails
I didn't
between
see
himself
any.
and Gall and Mr. Seebach.
And what do those say?
David Seebach was the arm of the DRC. It was a arm of the city, as admitted by the mayor. They were hired to be a straw buyer and buy these
Yeah,
properties in the
that's
city.
not law enforcement, though. I'm asking about the law enforcement.
Right, and then the emails go on. There are emails directly between Seebach, Peterson, and Chief Gall, the police chief. And before, I think it was immediately after the shooting outside of Pure, he said, "See, I told you so. We got to get rid of all of them." And he's not talking about all the bars. He's talking about the minority bars in the superblock. That is a statement from the chief of police, who was sitting in the sundown meeting.
So that's not, I asked you about
I'm
evidence
sorry.
that Peterson
He was on those emails.
shared his aspirations for the city to take over these properties, or somehow influenced law enforcement to make these decisions. That doesn't sound to me like what you're talking about. Is there evidence of that?
Yeah, there, again, it's the emails between the DRC, Chief Gall, and Peterson, where they're all discussing getting rid of the minority bars in the superblock. I mean, I don't know that it was necessarily for acquisition, but they wanted the minority bars
Is
gone.
this your 1985 conspiracy claim?
Yes, sir.
Well, what's wrong with members of the different parts of the city government talking among themselves? Is that a conspiracy?
It is if they're talking about getting rid of minorities, in my opinion, Your Honor. I mean, that's what they're talking about. They all admit these are minority bars. All of the owners are minority. Am I over? I apologize.
All right, I'm going to ask my co-panelists if they have any further questions. Judge Rushing. Judge Yoon. Thank you.
Thank you.
Mr. Humphrey.
Thank you, may it please the court. The issues before this court have little to do with the claims of racism that are appellants' near singular focus. Appellants devote most of their arguments to points which the district court did not reach or which are relevant to the issues which it did decide. Before the court today are discrete questions of law on just 3 of appellants' causes of action for which there are no disputed facts. Because the district court correctly answered those questions, this court should affirm. I want to start with the appellant's substantive due process claim, because that's the only cause of action which all the appellants have challenged before this court.
Before we get there, can I ask you whether the district court had any responsibility to take up the motion for a motion to amend the pleadings that was raised at the end of the defendant's case?
I'm not aware of a motion to amend the pleadings being raised at the end of the case. The only motion to amend the pleadings that I've been able to find in the record was a motion made at the end of the plaintiff's case, whereas Judge Yoon, you noted during my friend's argument, they asked to add Pure Ultra LLC as a party because there was some question as to whether Hector Melendez in his individual capacity could maintain these claims, and that motion was denied. I have yet to find a motion to amend to conform to the pleadings that was made at the end of the case to assert this amorphous Monell claim that they've raised. And I'll note that in their briefing, the appellants don't cite any portion of the record of the joint appendix where that motion was in fact made. The entire argument that they make is not about adding another party. They say that they made a motion to amend which, quote, specifically applied to a Monell claim, and even more specifically, they say it was a motion to amend the complaint to allege that if the city authorized John Peterson or anybody else such that the intercorporate conspiracy doctrine bars the 1985 claims, then they have a pattern or practice claim they can make under Monell. But again, I've yet to find that motion anywhere on the record, and I'm sorry, did you?
So I have a portion here where the plaintiff's counsel said at the end, after the district court granted a directed verdict, he said, I made a motion at the end of the first directed verdict argument that if we didn't have a 1983 claim for equal protection, that I wanted to amend the pleading to conform with the evidence.
And
So that's JA 942.
He did say, again, he said that after the directed verdict was granted, at which point any motion to amend would have been untimely. If you look back at the arguments of the first directed verdict motion, I can't find that motion that he's referencing. The only motion I can find during the first directed verdict argument is the motion to amend to add Pure Ultra
And
LLC.
that's absolutely correct based on the record, but I think he did, even if he didn't make that motion before, he said, I'm renewing this, there was no motion that he made, but he did say, at this point, I'd like to amend the pleadings to conform with the evidence. So you don't think that the district court was on notice to at least address that motion?
Well, if the motion is made for the first time after the grant of a directed verdict, then the motion is untimely. And the district court did address this issue in his ruling on the motion for reconsideration, where he said there was no timely motion to amend to add this Monell claim that was made during the trial, and it's inappropriate to raise it after the trial, either after directed verdict, or as he mentioned in that order, in a motion for reconsideration.
The motions to amend are generally subject to an abuse of discretion
They are, there's no,
standard, and there's also a futility exception. You don't need to amend if it would be, unless it would serve some purpose. And the question I have is, what would the motion to amend add that was not already there?
well, the motion to amend would add nothing, and Judge Wilkinson, you're right, the motions to amend are committed to the sound discretion of the district court. And
But
here-
just to clarify, that's totally correct, but district court didn't rule on futility, right? The district court, in his order, has a long footnote saying, there was this objection that supposedly saying about conforming the pleadings to the evidence, but that's not in conformity with Rule 15. That's not what happened here. That was an attempt to expand the pleadings in response to a DV motion. And, the court explained at length why he was ruling the way he was on that, and it's because there was no claim and no motion at all, and this didn't comply with the rules, right?
And that's correct, Judge Rush. The judge did not reach the question of futility.
Futility would be another additional reason, but we might review that de novo instead of for abuse of discretion, I would think.
Well, this court has the ability to affirm for any basis appearing in the records if the court were to find that a motion to amend would have been futile. That's certainly within this court's wheelhouse to say so. A motion to amend to conform to the evidence, which this would have been, also requires proof that the evidence admitted would not have been relevant to any other claim that was properly raised. It has to relate to something new. And this issue did come up in the briefing, where they have to show that if they want to claim that the city somehow consented to the trial of an equal protection claim, that the evidence to support that claim would not have gone to any other claim that was pending before the court. And they make no attempt to explain how this claim for equal protection, which was never timely raised to begin with, would not have also
The case was
supported their
pretty
other
well
arguments.
fleshed out. I'm just not sure what the amendment would have added. I mean, the substantive due process claims have been explored up here, the equal protection claims, procedural due process claims. They've all been pretty well fleshed out up here. I'm just not sure, reading the record, what difference an amendment would have made to anyone, to anything, because the basics of the suits, the basis of the different views were pretty clearly set forth.
That's correct, and there were other causes of action that were tried as well, tortious interference with contract. They had a takings claim that was tried. There was a civil conspiracy, not 1985, but a state law civil conspiracy claim that JBH&M had before the district court as well. So there's no contention that a Monell equal protection claim would have added anything to this case. And in the briefing, they refer to a generic Monell claim. Well, Monell did nothing more than allow municipalities to be named as defendants in 1983 suits. Prior to Monell, the
In
courts...
looking through this, it seems that the one precedent that's as much of a roadblock to these various claims as any other, is Judge Niemeyer's opinion in Sylvia Development. And Judge Niemeyer makes the point that substantive due process is very much out of favor at the Supreme Court. That due process is a procedural mechanism, first and foremost, that there's no substantive due process violation unless the action is wildly improbable, and unless there's no curative process. And when you look at our precedent in Sylvia Development, that's a hard case to get around in this particular lawsuit. And I have a fear if we started jumping into the middle of a cultural clash in a beach community with the Sylvia precedent standing out there, that the Supreme Court might take a close look at that.
Oh, and not just Sylvia, Judge Wilkinson, your opinion in Tri-County Paving, which was 7 years after Sylvia, announced the same principles, that both for procedural due process and for substantive due process, the availability of a procedure to cure the issue is absolutely relevant. If there is a state law procedure to challenge the action, then that precludes a finding of any due process violation, whether it's procedural or substantive. And I'll also note that for both the procedural due process claims and the substantive due process claims, the district judge found that sufficient process was available, and the appellants never challenged that finding on appeal. So therefore, they have waived any argument before this court that insufficient process and procedure was provided. And that arguably renders the appeal of those
Well, it's
causes of
not a
action moot.
pure zoning matter, but it certainly touches on local zoning authority. And some of the license applications were rejected for non-conforming uses under the zoning laws of the city, and our precedents have made clear that intervening in the local zoning process is something that the courts ought to undertake with the greatest of caution.
That's exactly right, and that's, as you noted, Judge Wilkinson, why the substantive due process case law has come down the way that it has. It's to avoid entangling federal courts in these sorts of issues where there is a specific procedure available. And it's also important to note that there's no alleged procedural irregularities that happened in how the license suspension and revocation decisions came down. The way the process works is a chief of police sends a request to someone in the finance office at the city recommending that license
It's
revocation.
odd that there was no Fourth Amendment claim here. We have everything else under the sun. We have substantive due process, procedural due process.
I think we're missing quartering in this case as well, because they did allege a violation generically of the first 10 amendments to the Constitution. At trial, they did try to claim a Fourth Amendment violation, saying that there had been improper search and seizure when police officers came into these bars and opened up the liquor cabinets and conduct investigation. But as was testified at trial by the expert.
So it makes you wonder, I was just reading the record, well, why is there no Fourth Amendment claim here? And it could have been a tactical judgment that if you made a Fourth Amendment claim, you would have to get into probable cause. And the specifics of the probable cause here might not have been all that favorable to those whose licenses had been denied or to those who were the subject of the police. They would explain why they had been there, and that might not have been that favorable. So I don't know. It would just cross my mind that might have been a wise tactical judgment.
Oh, particularly given the evidence that for Italia's Bar and Grill and for Pure Ultra, because those businesses sold liquor, the SLED, the State Law Enforcement Division, and police had an absolute statutory right to come in at any time unannounced and inspect and search the premises to make sure that they're complying with the liquor laws. And there's no allegation that the police coming into Natalia's or into Pure Ultra was somehow different in character or frequency or nature than the inspections that would have been conducted at any other bar. But to follow up on the substantive due process claim, even if you get past the hurdle to challenge the availability of process, there was absolutely process that was made available. Now, in addition to this multi-layer review before the revocation's even issued, the chief of police sends a
You know,
letter.
you start out with a presumption that this is a local matter and that the people of Myrtle Beach are going to be the ones that are going to be primarily affected. And the people of Myrtle Beach are the ones that are primarily, are closest to it. And it's their community, not ours. And then so the question becomes, you know, what justifies federal intervention into a matter which primarily affects the people who live in this community and their families and local businesses as well. And the federal courts do have a role, but the role seems to me a procedural role, not substantive or micromanaging zoning decisions and that kind of thing. And the procedural role here, as we've been over, was the initial investigation, the city council meeting, the state court proceedings. That sounds an awful lot like due process. And if there's some challenge that can be made to that, it has to be made in a more specific and substantive way than this record makes it. And as I say, you brought forward Mr. Conklin's testimony, and it was never refuted. And I'm just not sure that the case is made in other than conclusory terms as to why the procedural safeguards were somehow inadequate, and that would let us just jump into a substantive due process mode. That's part of the problem here.
And that's directly what Judge Niemeyer held in Sylvia Development. That's directly what you held on behalf of the court in Tri-County Paving. The federal court's role in these cases is to just ask, is the process fair, and to make sure that these decisions aren't arbitrary. The result of those processes isn't even a matter for the court. The court has held that what a state tribunal rules and whether there was technically a zoning violation or not is not going to be res judicata. You can have a case where, and this has happened, where the state court process comes back and says, this permit should have been granted or should not have been denied. And that still will not necessarily result in a constitutional deprivation that warrants federal court intervention, because that type of granular decision is not the fodder for federal courts on a due process claim. As long as the process was fair and the decisions were not arbitrary in a constitutional sense, then there can be no due process violation.
At the heart of procedural and substantive due processes was there something arbitrary. And I think that's why Mr. Conklin, or whatever testimony was brought forward, to show, well, you don't have arbitrariness here. I've looked at this from a national perspective. And if there'd been some refutation of it, I just didn't see it.
I agree, there is no refutation of that, and this sort of dovetails with their
And
section.
that was brought in to counter any impression of arbitrariness.
That's correct, and this gets into their 1985 conspiracy claim, where the district court held that in order to state a conspiracy to deprive somebody of equal protection, you have to show that, to avoid the intercorporate conspiracy doctrine, you have to show that racial bias was the sole motivating factor for the decision. And I don't think there can be any dispute based on the record here that this concept of public safety and redevelopment of the superblock was at least a motivating factor for the city.
To take an originalist perspective here, you would come to the conclusion perhaps that the framers did not want to override the ability of localities to ensure some peace within their geographic boundaries. And at the time of the adoption of the Constitution, there was an ancient tort of nuisance and of public nuisance that was well known to those who framed the Constitution. I think that the public tort of nuisance has been alive and kicking since medieval times. And it would be hard to surmise that the Constitution was framed in an attempt to eliminate the localities from taking into account that the concept that underlies that venerable tort.
And giving legs to that is testimony from Natalie Litzy herself. Ms. Litzy was the owner of Blazing Promotions, which is a business as a Tally's Bar and Grill. At her license revocation hearing, and this is at page 4540 of the JA, she testified to city council, it's a fact that they shoot in the area, let's clean it up. It's just not my establishment that's suffering, it's everybody in that block. And at the trial here, page 334 of the JA, she complained about the police not doing enough to correct issues involving crime in the super block. So there can be no doubt that this was at least a part of the motivation of John Peterson and others at the city to clean up the super block, protect public safety. And if it played just even a part of their consideration, that ends their claims as a matter of law. The court does not need to wade into any of these
All right,
questions.
thank you, counsel. I'm going to ask my co-panelists if they want to keep you up here a little longer. All right.
Thank you all very much.
Thanks. And Mr. Humphrey, excuse me, Mr. Player, you have some rebuttal time. Come on up.
Very briefly. After the initial DV motion, our primary concern was the 1985, even though we weren't presenting evidence. But there's one thing that you keep saying, that the expert was not refuted, and I just have to take issue with that. The city's given reason for what they did to my clients was fear of violence in the clubs. And we demonstrated with the sundown meeting with Henry Brewington, no violence had occurred, and they had already made that decision. When the emails circulated between the police chief, the city manager, and the head of the DRC, no violence had occurred in the clubs except for the one shooting outside of Pure. They targeted minority clubs for closure. If this was a beach community issue with safety, then why are the clubs that had 3-4 times the amount of violent acts at their clubs never cited for a nuisance? So our claim,
You may be right, you may be wrong, but the point is, the city felt that there was a real problem on their hands, and it's hard to believe that they would have taken the steps they took if everything was just proceeding beautifully. But the point is not necessarily whether you are correct or the city is correct. The question is, was there a process that the state provided for you to thrash the issue out? And they have it. They have it there.
and that may apply to the 1983. I don't see how that applies to the 1985 when they discriminated. A conspiracy occurred between Peterson, Seba.
I don't understand what this conspiracy is, in light of the intra-corporate doctrine, which a corporation cannot conspire with itself, and a city does not conspire with itself. You need some independent party. But the city manager talking to the police chief, those are the kinds of things you want municipal government to do. You want there to be a dialogue within municipal government with the city and the police chief and the inspectors and the rest, because you don't address municipal problems by building walls between the different parts of municipal government. And here you have concocted a conspiracy out of nothing more than intra-governmental communications which take place in every locality in the country. The different facets of government are trying to get together and put their collective mind to the question of how can we resolve a problem that is affecting our constituents, and how can we be most responsive to what our constituents are concerned about. And you said that kind of behavior which takes place in a democratic polity is a conspiracy?
Yes, Your Honor, you can't conspire to discriminate and shut down black bars. And that is a specific exception to the intra-corporate conspiracy. That if it's in for an improper, unauthorized purpose, then that doctrine does not protect
So
them.
you're leading us to the position that whenever you don't get what you want, there's a conspiracy.
No, Your Honor, I'm saying when the heads of the city send emails saying we're going to shut down the black bars, that is a conspiracy to deny them of their equal protection rights. That's where equal protection comes into this. It was the conspiracy amongst the people because the mayor said, we didn't authorize this specifically, dead to the point in his deposition. They were not authorized to seek the acquisition of any ongoing business. And their email showed that's exactly what they did.
There was a
And
public
it was
safety
driven by
there was a-
racial animus.
There was a public safety rationale behind it all, and there was also extensive testimony from, I think her name was Stephanie Parron, who is the city's regulatory officer, and she went into, again, unrefuted testimony about the number of non-minority businesses that were denied licensing as well. And whatever Ms. Parron, the testimony there again was not refuted. You've got all sorts of things that led the district court to direct a verdict here, and it was a lot of very relevant testimony that wasn't refuted.
Steph, she was refuted. During cross-examination, she admitted that she warned other businesses about the bad promoters, and she did not warn any of my clients. And that was one of the bases they used to take their businesses from them.
All right, sir. Thank you.
Thank you.
We'll come down and greet counsel, and Mr. Player, I'm always tell people that if you're sufficiently mad with me, you don't have to shake my hand. But I'm coming down to shake your hand. And I'm gonna.
You actually spoke at my law school graduation back in '94.
I spoke at your law school graduation?
I think so, yes, sir.
Well, congratulations. Did I give you your diploma?
I almost gave me a heat stroke because we were in those robes in the quad, and it was like 95 degrees outside. I was wondering how you maintained your energy.
All I can say is I'm glad some good lawyers, including yourself, were at that graduation. And I'm glad to know I was a speaker. Let's come on down and shake your hand. I now have Owners Insurance Company versus Walsh, and Mr. Wakula.
Good morning, Your Honor. May it please the court. Good morning.
Please.
I'm Stephen Wakila from Florence, South Carolina. Thank you for hearing from me today on behalf of the Walsh family. This matter arises from a tragic automobile accident that occurred when Mr. Walsh, who was operating a lawnmower, was struck by a vehicle that was traveling, I think, in excess of 130 miles an hour, causing his death. Mr. Walsh and owners agrees, the defense, or plaintiff actually agrees, that they insured defendant with underinsured motorist policies insuring two vehicles, a Cadillac and a Ford F-150. And they also don't dispute that owners under that contract is legally responsible to pay for damages that the Walsh estate is legally entitled to recover against the underinsured driver that struck him, whether Mr. Walsh was occupying any of those vehicles or not. Owners paid the coverage on only one of those vehicles. So the question before the court, as it so often is, I'm afraid, is this issue of stacking. South Carolina has been very clear on the point that stacking is presumed, that is to say, an insured's right to recover on the coverage under more than one vehicle is presumed absent an explicit and unambiguous policy provision prohibiting it. The estate argues that the district court and defendants flip that concept on its head and instead require the insured to show an explicit policy provision that requires stacking. And this is the essence of this dispute, I would contend. South Carolina law, Rupee in particular, but we cite numerous cases that make this point, presume stacking on the concept that the insured paid the premium, bought this coverage. The presumption is the insured is entitled to that coverage, where, of course, you can show that there's an underinsured driver that caused damages in excess of policy limits. None of that's in dispute here. The question is there an explicit policy provision that prohibits stacking? Now, this issue sometimes gets clouded in the minds of practitioners, I will concede, and the courts perhaps, because South Carolina law actually prohibits exclusions on stacking in certain situations. And there are voluminous case law in South Carolina under what circumstances a policy may not prohibit stacking. And frankly, oftentimes practitioners assume that the policy excludes stacking to the extent that South Carolina law would allow. And so we just learned these mandatory minimum stacking requirements, and we assume that the policy excludes to the extent the law would allow. However, it's always incumbent upon practitioners to read the policy. This is the contract between the parties, and particularly where, Your Honor, as here, there are somewhat unusual facts.
What significance do you attach to the fact that the accident here did not involve a covered vehicle or a scheduled vehicle?
Yes, Your Honor. Well, it is, I think there is significance there, Your Honor, in the sense that because Mr. Walsh was not occupying a covered vehicle, by South Carolina law, the policy could have excluded stacking. And that's significant, Your Honor. The point I'm making is it did not. And if it had, it must do so clearly, explicitly, and unambiguously. Otherwise, South Carolina presumes stacking. And had I not read the policy, had I assumed that the policy excluded stacking to the extent that the law would allow, we wouldn't be here.
How do you not read the Section 4B to be anti-stacking statute or policy?
To the point, Judge Union, none of the other exclusions apply. And they have to do with the nature of how an automobile is defined and so forth. The defendants point to now this one Section 4B. found, as Your Honor points out, at JA 131 to 132. Consider 4B follows 4A. And 4A is the one limit that applies. And I appreciate your question, Your Honor, and I promise I'm getting to it. 4A applies. 4A is the provision that says your coverage is limited to the extent of damages or the coverage that's listed in the declarations. That limit applies. The coverage limited in the declarations applies, and that coverage is $150,000 on 2 vehicles.
I had the same question that Judge Yoon had, and that is, I don't think the fact that this was a non-covered vehicle, it doesn't rule out uninsured motorist coverage altogether. But what it does is it throws you into what, as far as I can see, is Class 2. That the scheduled vehicles under the policy are a 1989 Cadillac and a 2008 Ford. And this was plainly not a covered vehicle. It doesn't rule out uninsured motorist coverage. You're entitled to recover. But the question is whether you should stack uninsured motorist coverage for a non-covered vehicle. Because I don't read South Carolina law as prohibiting or as mandating stacking. You yourself said it's at best a presumption. But I'm just wondering whether Section 4B is a permissible
Exclusion.
provision of an insurance policy, and I had the same question that Judge Yoon raised.
Yes, Your Honor, and I think the answer is, if it is explicit and unambiguous, limiting stacking, then it would be permissible under the law. The question Judge Yoon has is, how do you not read that as an explicit and ambiguous limitation? Well, let's read it. No limit of liability is increased because of the number of automobiles shown in the declarations. That the defense or the plaintiffs point to as an explicit and unambiguous limitation of the claimant's right to stack. No limit of liability, the only limit of liability that's at issue that applies that they point to is the declarations. No limit is increased. The defense doesn't seek to increase the limits beyond what's in the declarations. We seek precisely the coverage that's stated in the declarations for which we paid a premium. And then it goes on, except as provided in 4A above. Of course, 4A is the declarations. So 4B says, the defendants, the insured says, I'm entitled to the coverage that's stated in the declarations. Judge Wilkerson, you're quite right. I wouldn't argue that South Carolina law would prohibit an explicit limitation on stacking were there one. However, the insured says, I paid these premiums. Where is the explicit limitation? And the explicit limitation they provide is no limit of liability, the declarations, is increased. Well, we don't seek to increase it. We seek the limits that we paid the premiums for, $150,000 each on 2 vehicles. It's not increased because the number of automobiles.
Don't you have to read, 4A includes this however clause? If the policy insures more than one, your automobile, which is the issue that B1 talks about, right?
Yes, Judge Rushing.
Shall not be increased if you have more than, based on the number of automobiles. And then they have this clause in 4A that talks about, well, it will be increased based on the number of automobiles if you fall into one of these categories.
Well, I would say 2 things to that, Judge. The first is, recall, the presumption of South Carolina law is stacking. The purpose of the 4A.
And what's that?
Presumption for covered vehicles.
No, Your Honor. No, Your Honor. The presumption of South Carolina law is when one pays a premium for coverage under a vehicle and they suffer damages at the hands of an underinsured tortfeasor, they are entitled to that coverage
Excuse me,
absent.
Judge Rushing had a question.
Oh, I'm sorry, Judge. Judge, you point to the however section. And by the carrier's admission, none of these provisions of the however section apply.
Right, so the policy says when there's more than one automobile in the declarations, these are the rules that will apply to govern stacking. None of them apply here. And then you have this sort of belts and suspenders that says, outside of 4A, no limit's gonna be increased based on the number of automobiles.
Your Honor, I would take exception with that. And remember, we must read these exclusions strictly. Nothing in the policy says you can only stack as in the 4A2 however section. Had that 4B said that, Judge Rushing, had 4B said you shall not stack, explicit and unambiguous, except as set out in the 4A2 however section, we wouldn't be here. But it doesn't have that explicit and unambiguous limitation on stacking.
So you don't read the language that says the number of automobiles won't increase the limits outside of the provisions of 4A. You don't read that to say you cannot stack the two automobiles together outside of 4A.
No, Your Honor. And
What does that mean otherwise?
What does it say? No limit is increased because the number of automobiles shown in the declarations except as in 4A. Well, the first limit in 4A is the coverage on two separate automobiles of 100 body injury and $50,000 property damage. If there was nothing else in the policy, South Carolina law says the insured is entitled to the coverage on both those vehicles. So then where's the explicit limitation? The however section has four sections. None of them apply. None of those limits apply. 4B says no limit that we've talked about so far is increased. Well, no limit outside.
I have to say intuitively, I hear your argument, but intuitively, it seems to me a rather rough thing to not only give uninsured motorist coverage, which I think the insurance company is perfectly willing to do, but to provide for stacking of uninsured motorist coverage when an individual is sadly injured, not in a covered vehicle, but in a lawnmower, and to provide stacking for a non-covered vehicle, intuitively seems to me a heavy blow, and the combination of section 4A and 4B do not seem to me to go in your direction.
I understand, Your Honor, but absent our intuitions, what South Carolina law tells us is this. When a South Carolina insured pays a premium for an underinsured policy, whether they are in the car that's insuring or not, they are entitled to that coverage. And the presumption is they can have that coverage on each of the vehicles they purchase coverage on.
But under South Carolina law, a lawnmower is not a vehicle.
Yes.
So how would that presumption apply?
Well, what South Carolina law says is look to the policy, right? And first of all, even if the insured had been in no vehicle, no automobile and no vehicle, they would be entitled to underinsured coverage. Had he been a pedestrian and been struck by the other driver, he'd be entitled to underinsured coverage, and he would be entitled to the coverage on each policy, absent an explicit and unambiguous limitation. At the end of the day, the courts.
So remind me again, where are you getting this principle of South Carolina law that for a Class 2 insured, they are presumed to stack unless their policy says more than normal policy language about stacking?
And this is the essential question, Judge Rushing. If you read Rupee versus Auto Owners, it's that case and several others saying the same thing are cited in my brief, page 19. Stacking of additional coverage for which the insured contracted is permitted unless limited by statute or a valid policy provision.
Okay, so you're turning permitted into presumed?
Well, Your Honor, they tell us unless there's a statute or policy provision that says you can't stack, you can.
You can, right, but it doesn't tell us how to read a policy. It doesn't tell us, South Carolina presumes that you're stacking for a Class 2 insured unless the policy says something more than nothing about stacking.
No, quite the contrary, Your Honor. And permit me to disagree. South Carolina law says you get to stack unless, and it does tell us how to read a policy, unless there's a clear, unambiguous, and explicit exclusion. And if this court concludes that the reverse is true, that the insured must show an explicit provision that allows stacking because of our intuition that you shouldn't be able to get multiple vehicles if you weren't involved in had a car involved in the accident, you will have stood South Carolina law and precedent, which I cite you on numerous occasions.
So just to check, so that's your best your best authorities for a presumption?
Your Honor, I would point you to page 19 of my brief that cites Rupee and half a
Rupee.
dozen other South Carolina cases
Right.
that say repeatedly, you may stack absent an explicit and unequivocal exclusion. This court can only conclude in light of that precedent that the insured cannot stack if they find the contents of 4B to be explicit
All right,
and unambiguous.
thank you. Judge, do
Thank
you
you.
have any-
Sorry for going over time.
Okay, thank you. All right, we're pleased to hear from you, Ms. Baer.
Good morning, and may it please the court. My name is Laura Baer, and I, along with my co-counsel, Mary LaFave, represent Owners Insurance Company. The district court properly granted summary judgment to owners because stacking of underinsured motorist coverage was not provided for by South Carolina statute or by the terms of the policy where the insured was operating a riding lawnmower. There are two ways for an insured to stack under South Carolina law. One is for the statute to provide for it, and the other is to contract for additional coverage under your policy in addition to the minimum coverage provided by statute. Contrary to appellant's contention, there is not a presumption in South Carolina law that an insured may stack UIM coverage. South Carolina law characterizes a driver as either a Class 1 or a Class 2 insured with respect to the accident. Only Class 1 insureds can stack. Class 2 insureds can port their coverage on one vehicle. It was in compliance with South Carolina statutory law and the terms of our policy, which are consistent with statutory law, that we provided for portability of the coverage under one vehicle. The statute governing portability is SC Code 3877-160. If the insured has a vehicle in the accident, they are entitled to port and stack their UIM coverage, but only to the extent of the coverage on the vehicle involved in the accident. Here, there wasn't a vehicle involved in the accident under state statute because a lawnmower is not considered a vehicle under the statutory definition.
Can I ask you about that?
Yes, of course.
This is probably not relevant to resolving the case, but the statute doesn't actually define vehicle. The definition is for motor vehicle, and other statutes use motor vehicle consistently. But this one just says vehicle, not motor vehicle. Is there a difference? Does it matter under South Carolina law? I could not find any South Carolina law telling me why one is a vehicle and one's a motor vehicle. But the defined term is not used here. And do you know what that means, or if there's a difference?
Yes, Your Honor, I'm not sure as to why they use motor vehicle in some places and vehicle in others, but I would point the court to the Anderson case that's cited in our brief from the South Carolina Supreme Court, which was interpreting what vehicle meant under the uninsured motorist statute and determined that it meant a vehicle that is primarily designed for use on the highway. And so in the Anderson case, they found that a tractor was not primarily designed for use on the highway, and so it did not fall within the uninsured motorist coverage statute.
Yeah, we've got a lot of definitions happening here.
Yes, we do.
The lawnmower is an automobile under this gentleman's policy, but it's not a motor vehicle under South Carolina law, and it may or may not be a vehicle under this other provision, which again, I just raise it because I'm interested. It may not matter. But I wanted to see if you knew why there was a difference.
I don't know why there's a difference, but I know that the Anderson court looked to the definition of vehicle under the statute, or I'm sorry, motor vehicle under the statute to determine what vehicle meant in the uninsured motorist statute.
I think that might have been.
Or backwards.
Uninsured, but.
Uninsured.
Where they use
Sorry.
motor vehicle instead of vehicle.
That's
but
right,
it's-
that's right. So, and for purposes of statutory interpretation, we're looking at the statutory definition. So the policy definition of automobile doesn't then get read into the statute. First, you have to determine what coverage is provided by the statute, and then you look to the policy to determine if it provides any additional coverage beyond that. So turning to the policy here, the question is whether it provides additional coverage. And federal courts and state courts and federal courts applying South Carolina substantive law have all found that an insured is free to contract for additional coverage, but they have to do so by specific terms and a specific intention that's expressed in the policy that we're providing you more coverage than what's provided by statute. And here, I've looked at the cases cited in the brief, the cases cited within those cases, and the courts consistently look to the policy terms, and they have repeatedly found that no terms reflected an intent to contract for additional UIM benefits, except in some exceptional circumstances. Putnam is one of the cases that found that, yes, sure, you can contract for more, but you didn't here. Booth is another case where the court said, yes, you can contract for additional coverage beyond the statute, but you didn't do that here. So turning now to the owner's policy, Section 2 of the UIM coverage form is what provides for portability. We say that if you have damages that exceed what the underinsured motorist provides under their policy, then we will provide benefits. But Section 4 is what sets forth a limit on stacking. And so it's Section 4B, the provision that says that no limit of liability is increased because of the number of automobiles shown in the declarations except as provided in 4A above is our anti-stacking provision. And the district court properly found that that term of the policy was both explicit and unambiguous. There are two exceptions in 4A that permit stacking. One is for your scheduled auto. We're in agreement that that does not apply because there are only two scheduled autos under this policy. There's the Cadillac and the Ford F-150. The lawnmower was not a scheduled auto. The second provision that allows for stacking is 4A3. That allows you to stack where you have a vehicle that's not one of your scheduled autos, but it is subject to another automobile policy on which you have UIM coverage.
Would the result in this case be quite different if this were a covered vehicle rather than a lawnmower?
Absolutely. Absolutely. If it were a covered vehicle, he would be entitled to stack.
You're not trying to maneuver us into a broad anti-stacking pronouncement.
Absolutely not. Absolutely not.
South Carolina law wouldn't be with you.
No, it would not. And if our policy didn't allow that, then our policy would be in contravention to South Carolina statute.
So, I mean, it's to just put it in simple terms, it's crucial that the accident here involved a lawnmower and not a 1989 Cadillac or a 2008 Ford.
That's right. And it's also crucial that it didn't involve, let's say he had a minivan on his property that was insured with a different policy. He would potentially be able to stack on that as long as he had the minimum loads.
But even if the lawnmower had been involved in the accident, that still would provide, and you still would be willing to pay uninsured motorist coverage.
Yes.
This is not an example of an insurer that's just not willing to pay up.
No, Your Honor.
It's just that you don't want stacking provisions with uncovered vehicles. And 4A and 4B sort of interlock there. The Rupert case gives you permission to do it, and then you have the two provisions that interlock. And include an express anti-stacking provision for Class 2. But that seems to be the way it goes. This is not an example, as I understand it, of an insurance company that just is digging in its heels. It didn't seem that way to me, because you're willing to do two things. Number one, you're willing to stack if it were a covered vehicle. And number two, even with an uncovered vehicle, you're willing to pay uninsured motorist coverage.
That's right.
So this isn't that big, bad recalcitrant, because you're willing to do several things to make good on the policy.
That's right, Your Honor. And I think if we were to take the position that a Class 2 isn't even entitled to portability, that would be in contravention to the statute and our policy provisions. That's not what we're saying. We have tendered $150,000 in benefits, which represent the portability benefits on one vehicle. So we're treating him as a Class 2. So we agree that he doesn't fall within 4A1.
Do you want to continue this, or do you have any questions? You have none, okay. Do you have any further questions? All right, the panel has no further questions of you, and we appreciate very much your argument. Thank you so much.
Thank you, Your Honor.
All right. Mr. Wukila, do you have some rebuttal time, sir?
Thank you, Your Honor. Respectfully, Your Honor, carrier didn't make those payments out of the goodness of their heart. The insured paid a premium. He paid a premium for two separate vehicles. Judge Rushing asked me about the law, and the courts of South Carolina have been very clear, and I'm reading from page 13 of my brief. Stacking of additional coverage for which the insured contracted is permitted unless limited by statute or policy provision. That's Rupee from 1998. Jackson in 1986, Beaufort County School District versus United National in 2011, the Court of Appeals, State Farm versus Wyndham in 2020, quoting Rupee, this court met in 2023 in Mims versus USAA. There is a presumption that when you pay the premium, you're entitled to the coverage, absent a clear and unambiguous limitation. This court, in order to find that there is not stacking, must find that 4B is such a clear and unambiguous limitation. 4B reads, no limit of liability is increased by the number of automobiles shown in the declarations, except as in 4A. 4A begins with exactly the declarations of coverage of 100 and bodily injury and 50 on each of two vehicles that the insured paid the premium for. Now, this court may find, no, that's not the law. South Carolina law is not that there's a presumption. Judge Wilkinson points to South Carolina's minimum requirement that if you have a covered vehicle in the accident, you can stack and the carrier can't prohibit it, and you don't have that minimum required if you don't. And that's actually not the minimum, that's also the maximum. But that's not South Carolina law. That would be a reversal of the pronouncement from the South Carolina courts for decades. This court can then only conclude, in light of South Carolina law, that that provision 4B is explicit and unambiguous in that it prohibits stacking, absent the four sections and however. It doesn't. No limit of liability is increased. That's an explicit and unambiguous exclusion of stacking. I understand the court's intuitions about when a person who pays a premium should be entitled to stack. That's not what South Carolina's presumption is, and that's not what the insured paid the premium for. With that, I conclude my arguments unless there's further questions from the court.
Jasmine, do you have a question?
I just want to confirm, when you talk about presumption, the best case or language that you pointed out was the permitted language from the Rupee decision?
Yes, Your Honor. Jackson says stacking is generally permitted unless limited by statute or policy provision. generally stacking additional coverage which insured is contracted is permitted unless limited by statute or policy. Permitted is the phrase they use. But remember, that's taken in also in hand with South Carolina's law that has been explicit that we read policies strictly and we read exclusions and limitations strictly. Thank you, Your Honor.
Jasmine, do you have any questions? All right, we thank you. We'll come
Thank you.
down and greet counsel and move into our final case. All right, Mr. New.
May it please the court. Good morning, Your Honors. My name is Stephen New, and I'm from Beckley, West Virginia. I stand before this court proudly representing every inmate, prisoner, and juvenile detainee in the state of West Virginia in this important action against the governor of the state of West Virginia, Patrick Morrisey, and the Cabinet Secretary of West Virginia's Department of Homeland Defense. Our position is simple. The district court erred in dismissing the plaintiff's claims against these two defendants on the basis of standing. This court, the standard of review is de novo. The two primary issues upon which the court granted dismissal was a finding that the plaintiff's claims were not fairly traceable to the governor of the state of West Virginia and the DHS secretary, and that the injuries would not be redressed by a favorable decision.
May I ask why the head of the Department of Corrections is not a defendant here?
Your Honor, the head of the Department of Corrections is a gubernatorial cabinet appointee under West Virginia Code 15A-3-3. And the reason why the commissioner was not included as a defendant in this case, it's easily remediable, but it is the cabinet secretary, the DHS secretary, who under West Virginia Constitution Article 7-18 reports to the governor 10 days prior to the legislature meeting. And so it is the cabinet secretary who reports on corrections from the commissioner to the governor, who then the governor under the West Virginia Constitution develops the budget or a proposed budget to submission to the legislature. So our position is that inasmuch as the commissioner of DCR under West Virginia...
But the secretary's role is purely advisory, is it not?
I don't believe that it's purely advisory, particularly under that portion of the...
Well, that would come as a surprise to the legislature of West Virginia.
what would come as a surprise to the legislature of West Virginia? I believe that the Cabinet Secretary has much more of a role than to simply be advisory on the matters of corrections. True, the Commissioner of Corrections carries out the day-to-day operations, but the Commissioner of Corrections has no ability to propose a budget for corrections to the governor. That comes through the Cabinet Secretary for the Department of Homeland Security, Your Honor.
But your clients, your clients say they were given inadequate food, their showers had only scalding water, these sorts of things. Who can fix that? Isn't it the head of the Department of Corrections who has the authority to fix what is going wrong in these prisons and affecting your clients?
Not without adequate funding.
Right, but that's their problem to figure out. You don't sue the legislature and ask them to fund something because someone has inadequate food. The court can order the head of the Department of Corrections to provide adequate food. The court can't order the legislature to spend their money a certain way. That's a byproduct of a court order.
The problem in this case, Your Honor, with all due respect, the problem in this case is that these problems, including those maintenance issues, is following. The former commissioner of the Division of Corrections and Rehabilitation on many occasions, and her chief of staff, approached the previous Homeland Security Secretary, Jeff Sandy, and the governor's chief executive and the governor's office requesting funding, requesting additional funding for the deferred maintenance. And the additional funding for to address the staffing shortages with correctional officers and the overcrowding, some funding, all of that was ignored, largely for the entirety of the 8 years.
What's being ignored is the whole question of standing. We tend to argue the most standing questions over the matter of injury and fact. But the fact is there are three elements that have to be established in proving standing. And the second element is causation. And the third element is remediation. And it seems to me that you face some problems here in terms of traceability and redressability here. That you've put these two defendants up there, and number one, it's unclear that they caused anything, and number two, it's very unclear that they have the capacity to redress anything. And that's before we even get into the merits, which present all kinds of sovereign immunity problems and ex parte Young problems and ad infinitum. But the initial question here is standing and questions of traceability and redressability. And those are every bit as important an element of standing as injury and fact.
Yes, and I'm happy to tackle those, Your Honor. In terms of traceability, let's look at traceability of the governor of the state of West Virginia and the Homeland Security Secretary. It's traceable to the actions and inactions of the governor of the state of West Virginia because during Governor Justice's 8 years, he declared 2 states of emergency due to understaffing.
Are you claiming that declaring those states of emergency caused these problems?
No.
Okay, so how is that related to traceability?
The traceability in that he had the power to address problems like we allege here with overcrowding, understaffing, and overdue maintenance.
No, he doesn't have the power. The legislature has to appropriate the funds.
And the governor of the state of West Virginia has the ability. The governor of the state of West Virginia proposes a budget to the legislature based upon the recommendation of the cabinet secretaries who submit to him a proposed budget.
Well, I mean, a lot of governors would be delighted to learn from you that the legislature was obliged to click its heels and spend whatever the government had proposed. But as we all know, there are all kinds of executive budgets, both at the federal and state level, which legislatures have declared dead on arrival.
Yes, and under West Virginia's Constitution, Articles 7-14 and 7-15, it gives the governor the power to veto those budgets. And frequently during Justice's 8 years, he called for special sessions. For instance, in 2023, there were 6 corrections bills passed that addressed understaffing.
So I guess you could sue the governor for pretty much anything that involved the state government, right? Because he could propose a budget to the legislature to spend money in a way that would potentially, if the legislature enacted his budget, give funds to address the problem the way you want it addressed, right? Not just prisons, I mean anything that requires money from the state.
No, we're talking about constitutional
Well, why?
entitlements.
Why is your theory of traceability and redressability, why is that not where it leads? That someone could sue the governor for anything that requires money in the state because it's traceable and redressable ultimately to the people who might propose a budget that might go to the legislature.
It becomes different when there is constitutional liberties involved here. This is the Eighth Amendment.
Tell me why the standing inquiry is different because of the Eighth Amendment.
Because it is clearly traceable to the governor and the Secretary of Homeland Security, and the injuries would be redressed by a favorable decision here, just as in the August.
Sorry, tell me what are your reasons why this situation was different from any other expenditure of state funds?
Because there are constitutional liberties involved here.
We're going to have governors all over the country dragged into court.
And they are.
Yeah, right.
And they are frequently, Your Honor.
Maybe, but the question is whether they're permissibly dragged into court, and you're going to have the governor of West Virginia for any complaint about any aspect of state government that someone thinks is underfunded. We're going to have the governor hauled into court as both the cause and the object of remedy. And the problem here with this sort of lawsuit is it seeks to co-opt both executive authority and dragging the governor into court, but it also is co-opting legislative authority, because these suits tend to focus on only one state need, which in your judgment has to do with the prison system. But legislatures are not afforded the luxury of focusing on one state need. They have to juggle priorities. And in addition to the prisons, they've got to look at funding for schools in West Virginia, for colleges, for roads, for hospitals, for Medicaid outlays, for environmental improvement, environmental sanity, for law enforcement. They've got to juggle all kinds of priorities, and they have to have many, many deserving claims for funding are competing against each other. And the problem that the Supreme Court has found with this type of suit is that it seeks to co-opt legislative authority by focusing and asking the courts to focus on one particular area when legislatures have to, in their allocation functions, in their spending functions, have to canvass an array of state needs. And what authority do we have to elevate one particular claim for budgetary outlays over the environment or over law enforcement or over schools or over Medicaid or over so many other things. You are asking us, in addition to changing this court's law on traceability and redressability, you are asking us to invade the heart of executive authority and legislative authority, and there's a big separation of powers problem that lies at the basis of the standing ruling that the district court made. And that's not even getting into the deliberate indifference standard and the ex parte Young standard and the sovereign immunity issues that lie in the event that one even got to the merits.
The authority this court has is found at Brown v. Plata, which is a PRLA case from 2011, 563 U.S. 493, 131, Supreme Court, 1910, which said that the federal government...
Was there a three-judge district court panel under the PLRA in this case? Did you sue under the PLRA?
No, not under the PRLA.
Okay, so this suit is not about that.
Correct.
Okay.
But in Brown v. Plata, the court does have that authority. And to your point, Judge Wilkinson, about whether or not the governor of the state of West Virginia can be hauled into court, this court decided in Jonathan R. v. Justice, 41 F. 4th, 316, the 2022 case involving West Virginia's pitiful foster children
But that
system.
case did not address standing, did it?
No, it didn't address
So how
standing.
How can you rely on that case if it didn't discuss standing at all?
Governor Justice was appropriately a defendant and remains, Governor Morrissey remains an appropriate defendant in that case. And perhaps the defense lawyers didn't raise the issue of standing, but Governor Justice...
But that's pretty crucial, isn't it? I mean, there's a big boulder in the road, and it's called standing, and part of the points we've made in our precedent is that the general duty to enforce the law, which every governor has, doesn't confer standing, and where redressability depends upon a third party, here the legislature, that doesn't confer standing because the redressability depends upon a third party's action. And what you're asking us to do is to overlook those precedents and pronouncements in the way of standing and to get on a broad, equitable suit that has the court saying what outlays are constitutionally adequate, which parts of the penal facilities are those outlays going to go to, which needs should be met, which prisoners should be released, which should be detained. And this would go on and on and on, and we would be having courts exercising equitable powers over the daily administration of the prison system, and it would be never ending because whatever was proposed would be inadequate and the subject of another appeal. And that's where you're going. And it has problems with standing, it has problems with the precedent, it has problems with separation of powers, it has problems on the merits. Do you understand I have a problem?
Sounds like it, Your Honor, yes. But we still think that we're right. These prisons have been pitiful in West Virginia for over a decade. And the governor, whose job it is to ensure that they run constitutionally permissible, didn't do his job for 8 years. He said he turned cow dung into gold. He lied about a $1.2 billion budget surplus when it was $400 million in the red. Now, Governor Morrissey gets to deal with that. But I understand that Your Honor has a problem with that. But these prisoners still suffer. And the people in charge of ensuring that they don't suffer do little to nothing except...
Counsel.
You may or may not be right, sir, but it is not the suit that you have brought.
We believe that it is, Your Honor. I'm into my rebuttal
Now,
time.
you know, I don't ever want to have the last word on anything, so You go ahead now. You're going to get the last word, and tell me why everything I've said is just crazy.
Because the Eighth Amendment, the issue we're here on today is standing, having to do with traceability. This is traceable to the governor of the state of West Virginia if this court looks only at his actions in August of 2023 and 6 Senate bills in an interim session that were governor's bills that the governor proposed, $21 million in corrections officers' pay raises, bonuses of $5 to $6 million to alleviate the understaffing that we allege in this case. Those bills alone in August of 2023 prove that Governor Justice possessed the power to address the unconstitutional condition of understaffing. And so that hits on both of the elements that we're here on today in terms of standing, traceability to the governor, the ability to call a special session, the ability to propose governor's bills, and that addresses only staffing. That doesn't also address the $277 million of overdue maintenance, as well as the chronic overcrowding in West Virginia's jails, prisons.
Have you given some thought to bringing the issues with bonuses and staffing and other such things to the legislature or to the Department of Corrections?
Yes.
Well, why did not the thought take hold?
We have brought individual suits, Your Honor, to address those.
Okay. All right.
Thank you.
Thank you, sir. Mr. Ritchie.
Good morning, Your Honors. May it please the court, I'm here on behalf of the governor. This case is all about money. Money to remedy alleged overstaffing, money to remedy alleged overcrowding, money to remedy alleged deferred maintenance. That is the entire essence of the complaint. But the federal court cannot give the remedy plaintiffs seek for several different reasons, least of all against the 2 high-ranking officials sued in this case. The district court should be affirmed. My friend, Ms. Schaefer, will address standing as to the secretary, and I'll address the same as to the governor and the other remaining arguments in our brief. The district court got it right on standing. The harms alleged are not traceable or redressable to the governor because he can only propose appropriations, which lies, of course, with the legislative powers. To the extent the complaint seeks some generic non-monetary changes, particular collection policies or regs, the governor, of course, lacks the authority over those discrete matters under state law. Under this court's case, Disability Rights versus McMaster, the court says we need to look to ex parte Young principles to analyze standing, and plaintiffs here point to the governor's general supervisory authority and nothing else in their complaint. But that's not enough under this court's ex parte Young precedent. That's Waste Management versus Gilmore, and more recently in December, King versus Yunkin. That's 122 F. 4th 539. There is required a special relation between the challenged law and the official's authority, and here that means, as this court has said, it means special relation means responsibility for and proximity to the challenged law. But that's wholly lacking here. The governor, as indicated, lacks the power to appropriate. Of course, he is obligated to propose budgets. He can veto what the legislature enacts, including line items, but he cannot enact appropriations himself. Nor can the governor write correctional policies and regulations, which, as my friend Ms. Schaefer will talk more about, falls to the commissioner of corrections, an official that, again, plaintiffs strategically declined to sue in this case. And for these same reasons, the district court was right to conclude that the plaintiff's claim is not redressable by the governor. In its briefing, but nowhere in the complaint, plaintiffs assert redressability can be satisfied because the federal court can force the governor to use his pardon or commutation powers to relieve overcrowding. There's many reasons why that's inappropriate, but least of which it's not alleged in the complaint, nor is there alleged, as my friend acknowledged, any claim under the PLRA. And this court can affirm for other reasons. On the record, as indicated by Judge Wilkinson's earlier, there are numerous problems here. We believe, as raised below, the plaintiffs have failed to state a claim, an Eighth Amendment claim under both the objective and subjective prongs of deliberate indifference. And specifically here, we think plaintiffs have essentially pleaded themselves out of court by focusing on the subjective intent of the governor to improve the conditions, not simply that he disregarded them. He was actively trying to improve them. And the complaint lists a litany of those actions. And as to the secretary, plaintiffs make no allegations against him at all on the subjective prong required to sustain an Eighth Amendment claim. And so for that reason, the court can affirm for failure to state a claim. Another aspect of Ex parte Young and state sovereign immunity is that the court simply cannot order the payment of money to remedy constitutional violation. Here, the payment of state funds is not simply incidental to injunctive relief. It's a central essence of the relief being sought by plaintiffs, and I don't think they deny that. And such relief would also violate the 10th Amendment. The federal judiciary cannot commandeer the state legislative and executive machinery to operate state correctional institutions by compelling legislative.
All of the problems involving sovereign immunity and the application of the deliberate indifference standard and the applicability of Ex parte Young and all of the rest of that, there's no need for us to get into that. Because the threshold issue, and the one that the district court decided, was simply whether Article 3 is engaged at all through standing.
That's correct, Your Honor.
So these other things are additional problems that would appear in short order if they were on the merits. But I don't know that we can do a thing unless we have basic jurisdiction over the case of controversy, and if we don't, then it stops right there.
We agree completely, Your Honor. It's simply that if the court does find standing, these issues are available for the court.
There are multiple issues, but they're not, they don't have to, they're far into the future.
One final comment, and I'll take my seat if there are no other questions. My friend mentioned that there are governors sued in other cases, other civil rights cases, or even prison cases. A couple issues there. Frequently, in many of these cases, the governor sued alongside other proper prison officials. But secondly, and perhaps most importantly, none of those cases discuss standing, as the court had mentioned, and so we cannot take anything from those cases where standing is not challenged. So ultimately, it's kind of hard to imagine a greater violation of federalism or the separation of powers if this case is permitted to proceed. The district court should be affirmed.
Well, Judge, thank you.
Thank you.
All right, Ms. Schaefer, we'd be pleased to hear from you.
May it please the court, my name is Natalie Schaefer, and I, along with my co-counsel, Kimberly Bandy, are here on behalf of Robert Cunningham, the interim acting secretary of the West Virginia Department of Homeland Security in this matter. For the same reasons as my friend representing the governor, the secretary, the cabinet secretary, is likewise subject to dismissal for the reasons stated by the district court, and we ask this court to affirm the dismissal of both defendants under Article 3 standing. The plaintiff in the appeal, plaintiff in the underlying case as well as in the appeal is attempting to assert a class action which has not been certified yet. We haven't gotten to that point yet. Due to conditions of confinement involving overcrowding, understaffing, and deferred maintenance. The court should affirm the reasons for the district court's ruling as to the cabinet secretary for three primary reasons that permeate throughout this matter. One, the complaint fails to identify any policies, procedures, or practices that need to be implemented or enforced as requested in the prayer for relief. Second, the secretary, the cabinet secretary, does not have any vested authority whatsoever to implement or enforce any policies, procedures, or practices as requested in the prayer for relief. And third, the Cabinet Secretary does not have the vested authority to appropriate or otherwise spend state budget surplus funds as requested in the prayer for relief. That, as the court noted, is the exclusive province of the legislature. Simply put, the plaintiff lacks standing, and indeed, the complaint itself is self-defeating. The plaintiff cannot establish traceability or redressability against the Cabinet Secretary, despite multiple attempts throughout appellate briefing to invoke additional new arguments in terms of additional avenues for redress or means or methods for redress. I would remind this court, this honorable court, that a review of the complaint is absolutely critical. And this court has specifically held on numerous occasions when a plaintiff is attempting to seek injunctive prospective relief, such as this matter, it is important that the court review the relief that is actually requested in the complaint, because that is what dictates what is or is not actually achievable or redressable, traceable by the defendants. And that is where the first step of this analysis, before we get to the merits, that is where this case fails, as the court noted. I would like to point out, in my time remaining, that in addition to failing to allege any violations of policies or procedures or anything that is systemically widespread that can be addressed by a high-level executive such as the Cabinet Secretary, I would like to point out that my friend on the other side referenced Jonathan R. versus now Morrissey, which was a case pending regarding in West Virginia in the Southern District regarding the foster care system. I would like to point out to the court, although certainly not precedential, Judge Goodwin recently, I believe in February of this year, issued an opinion addressing Article 3 standing, and it is almost exactly on point. Of course, the paradigm is within the foster care system, but the legal paradigm with respect to Article 3 standing is absolutely applicable.
Which case are you talking about?
This is Jonathan R. versus now Morrissey, Governor Morrissey, and the site, the Lexus site is 2025 U.S. District Lexus 36435. And Judge Goodwin issued this opinion sua sponte. Nobody raised the issue in briefing. But Judge Goodwin pointed out that the federal court is one of limited jurisdiction. It is not to set policy. They do not legislate. They do not govern. And the principles are not abstractions. They're the foundation of constitutionally established tripartite government. And Article 3 standing does not permit federal courts to exercise general legal oversight of the legislative and executive branches. This decision, and I am out of my time, but I would point out that the one additional comment that Judge Goodwin made, and again, not precedential, but he did state specifically that the federal court cannot write a state budget, hire state employees, or oversee child welfare administration for the very purposes and reasons that Judge Wilkerson mentioned earlier, because this is a state matter. So unless there are any questions, I'm concluded. Thank you.
Well, we thank you very much. Mr. New, please come forward. We're happy to hear from you in rebuttal.
Very briefly, this court does not have before it the merits of this action or any other basis. The district court did not dismiss this case on 12B6 grounds for failure to state a claim. It was 12B1 standing only. The court has heard the arguments here, and in response to the Cabinet Secretary's counsel, my friend, she said that the Cabinet Secretary has no authority. It is the Cabinet Secretary, not the Commissioner of Corrections, who submits the corrections budget to the governor 10 days prior to the legislative session. It is not the DCR Commissioner who goes through the governor's office to put the corrections budget in place. That is reviewed by and submitted onto the legislature from the cabinet secretary. And in closing, the court's heard the arguments. The court has the power under Supreme Court precedent to correct Eighth Amendment unconstitutional conditions. Courts don't just give up their powers to enforce the Constitution of the United States of America. The executive does not remain unchecked. The legislative does not remain unchecked when there are constitutional harms involved. And if courts give up, God help us, everyone. But neither.
Well, let's remember, so you mentioned Article 1 and Article 2, and that there are constitutional amendments that courts also enforce, but Article 3 is what gives courts the power to enforce those. And if we reach beyond our authority, then that's also a problem. We don't have the authority to enforce every constitutional provision that we would like in any case. You have to show us that there is standing, that there is an Article 3 controversy that is ripe, that is within our power. So I don't want to take your thunder and your concluding lines here, but I have to point out that our power is limited as well, just like the executive's power is limited and the legislator is limited, all by the Constitution.
And we believe that we have shown traceability and redressability on the issue of standing alone, because neither of these appellees have the right to violate the United States Constitution. Thank you very much.
All right, we thank you, and we will adjourn. I want to thank our courtroom deputy for the fine job that she's done, and also want to say what a pleasure it is to have Judge Yoon with us for her inaugural sitting, and she's off to a great start on the district court. And we'll come down and we'll adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.